Let's begin formally on behalf of this platform for discussion, Center for Legal Change. It's not an organization, just a platform that brings together people to exchange views on how law changes society and how society changes the law, this interaction. And so we are very pleased to have this discussion today on a very important issue, the power of Lokayuktas to remove public functionaries. The immediate context of this discussion is the, as we all know, is the recent controversy over the ordinance issued by the government of Kerala, which converted the, which amended the Kerala Lokayukta Act, which provided for mandatory resignation of highest level public functionaries upon a declaration by the Lokayukta that complaints against them were substantiated, to to treating them the declaration as a recommendation rather than as a binding decision. This naturally set off a continuing controversy and debate inside Kerala, but it has also ignited perhaps the most difficult question in our legal framework on anti-corruption, which is ultimately, what do we do when a elected official, wherever he or she may be, at whichever level, an elected official who is a legislator or a minister, is after a due process by the Lokayukta found to have done, engaged in some wrongdoing, who then should have the power and authority under the constitutional scheme to remove that elected official from office where there is misconduct or corruption or maladministration. Now, this perhaps is, we've heard many times the cliche that the fish rots from the top, from the head. We know that ultimately corruption cannot be controlled unless corruption at the top is effectively controlled. It's a sad thing that 70 some years after independence, we still do not have an effective legal framework that will hold public officials, whatever their background may be. What we are discussing here is not at all from a political point of view or ideological point of view. We are looking at it purely from a legal, constitutional point of view, governance point of view. And so from that point of view, there is no effective legal framework to hold a elected official effectively accountable when found to have engaged in wrongdoing. Now, why that is a very long discussion. Our overall framework for combating corruption is renowned to be very ineffective, even after 70 years, starting from the setting up of a vigilance establishment in the 60s, pursuant to the Santanam Committee report, and that has been strengthened through the Lokpal at the national level and Lokayuktas in 21 states. Over the Lokpal came in 2013 through the 2013 legislation. Is just actually starting to be formally established and getting on its feet. But Lokayuks have been, we have 20, in the major states, we have 21 state laws on Lokayuks. So there's an elaborate framework. Crores of rupees are being spent to maintain this framework, but we don't see any impact on corruption on the ground as far as common people are concerned. So in this vast issue, we thought after discussing with the resource persons and others, that we can focus within this limited time that we have on this narrow question of what do we do, assuming that a elected official is found to have committed a criminal act like corruption or some other criminal act or engaged in misconduct. What is the ideal mechanism that can be envisaged or is envisaged within the constitutional framework of separation of powers and accountability and rule of law to hold that public official official accountable and remove that public official. To discuss this today, we have three extremely distinguished and extremely renowned resource persons from three perspectives. Justice A.K. Sikri, Justice Arjan K. Sikri is, I think everyone will agree, is one of the most erudite, learned, respected, independent, balanced judges that we've had in the Supreme Court in its entire history, I would say. A person who brought to the Supreme Court not only an exceptional brain, but also an exceptional heart, which is a rare combination. And I've had the privilege of knowing Justice Sikri for much of my life, from when we were students at the Campus Law Center. And we know that he will give us a very sincere, very honest, very erudite view on this very complex issue. We're also very privileged to have with us Justice Manmohan Sarin, who also has an exceptional reputation for his independence, his integrity, his competence, and the conscientiousness with which he also applies his mind to bring to bear both justice and compassion to his work. And a judge who has mentored many very senior judges of our country over the years, been Chief Justice of the Jammu and Kashmir High Court, and actually been very effective and very active Lokayukta of Delhi for 5 years. And people realized then that there is a Lokayukta in Delhi. And so he brings experience from the Lokayukta seat, in addition to vast experience from the judicial seat. And we have Ms. Anjali Bharadwaj, who is again one of the most respected and independent members of civil society, part of the core team that brought us the right to information, and also now a prominent anti-corruption activist, has been recently named by the United States as one of 15 global leading anti-corruption activists. And so we have a civil society perspective, an erudite perspective of a jurist, and an erudite perspective of not only a jurist who's also been in the chair of Lokayukta. And it's a privilege to have all of you here. We have 90 minutes, of which about 15 minutes have now gone, but the time remaining is at your disposal. We are recording this. This is live on YouTube, and in addition, we will record it, and we'll put each of the interventions separately. And if there's a discussion, if there is time, we will have a discussion, but it's more important for us to hear you carefully and hear you with adequate time for each of you to put out your views, for the public to be informed about the various legal aspects and the civil society aspects of this very important issue. Once again, thank you very much for sparing your very valuable time.